Hello class, welcome to Public Law. This will be session 5 with me. This is part 2 on the topic of separation of powers. All right. So in part 1, I did the 2019 Zone B question 3. Today now in part 2, I will be doing the 2018 Zone A question 1. This would be on page 14, of your notes, which is the first bundle of notes that I gave you. All right, so from the first bundle, that means British Constitution, Conventions, SOP. All right, so I'm on page 14. Okay, right now before we start, I'm a bit fed up of this mantra now. You'll be bored, right? So we'll have another one for today, well, for 1 or 2 sessions. Not sure whether you are familiar with this face. Recognize who that is? Well, I close my face. Look closely. Correct. Those of you who guessed, that's Napoleon on his beloved white horse up the Alps. And look at his sign of victory. Okay, so that's our motivation for the day. Okay, that's it for social niceties. We'll go into the question now. Got to work to try to, where's my pen? Pen's run off somewhere. There it is. Okay, read the question please on page 14. It says, consider whether the UK constitutional system more resembles a balance of powers than a formal separation of the 3 branches. All right, consider whether the UK constitutional system more resembles a balance of powers. So we've got to look at what is balance of powers means, than a formal separation of the 3 branches. So formal separation of the 3 branches, we know that means a pure system of SOP. But what does a balance of powers actually mean? All right. Now, if you've got a pen, the Webster definition of balance of power is as follows. Webster definition, the dictionary definition is this. A balance of power means an equilibrium of power. Okay, an equilibrium of power. Feel free to go and bring a cup of tea or coffee and put it next to your desk wherever you're sitting. This will probably take anything between half an hour to 45 minutes. Yeah. Okay, so the Webster definition of balance of power is an equilibrium of power sufficient to discourage or prevent one side or party from imposing its will or interfering with the interests of another. I repeat, balance of power means an equilibrium of power sufficient to discourage or prevent one side from imposing its will or interfering with the interests of another. So let's apply that to the British Constitution, right? So is it true that there's a formal separation of SOP? Definitely not, right? So is it true that it's more of a balance of power? Yes, it's true, but only to a certain extent, because it's not always balanced. And there will be, this answer will argue that there will be some instances where the power of one particular branch, for example, Parliament, may be more domineering over the other branches. So sometimes that balance may be dislodged. Okay, one very good example of that happening was when we had the Burma Oil case, followed by the War Damages Act, where that balance seemed to be, dislodged in some sense. So yes, it's definitely not a formal separation of powers. It's more of a balance of powers. But a balance of powers means a situation where different sides have roughly equal power. That's not always the case in the British Constitution. Okay, so number 1, respond to the question. We've done that. Number 2, meaning of SOP. Number 3, how SOP works in a codified constitution compared to an uncodified one. Number 4, overlaps in the system in the UK. Number 5, what are the checks and balances? Number 6, what did the CRA reform do? Number 7, any other reforms? Number 8, different schools of thought on SOP. Number 9, judicial review and the concept of justiciability. Number 10, conclusion. All right, so let's come back now to the beginning. So on your page 14, so respond to the question. We've done that. Let's move to number 2. So number 2 is the meaning of SOP, and here you can refer to classic definitions or classic theories, people like Aristotle, people like John Locke, but and also people like Montesquieu. The Montesquieu's version of SOP is definitely what we call the formal separation of powers, where there is that walls, so to speak, between the three institutions. Yeah. So having done that, if you look at number 2, the purpose of SOP to avoid absolutism in power, right? To ensure that the powers, functions and personnel are demarcated properly. So Parliament is the lawmaking body, the executive and the institutions in it implement the policies, and the judiciary, made up of judges, is there in order to interpret statute passed by Parliament. And then number 3, how does SOP work in a codified constitution compared to an uncodified constitution? So there is a more formal separation in a codified constitution in that sense, because the rules are more clearly laid out in the sense, for example, if you look at the bottom of that page, you'll see the president is elected by a separate election in the US than that of the legislature, i.e. the Congress. The members of his cabinet are appointed by him and not derived from Congress. So this ensures the separation of the E and the L, which we don't find in the UK. So in that sense, there's more of a formal separation in the US. The Supreme Court judges in the UK's, they have special powers, which the Supreme Court judges in the UK don't. They can even, declare an act of Parliament, declare law to be invalid, to be unconstitutional. But then again, even in a codified constitution, like the US, it's not true to say that the Supreme Court judges are elected completely independently from the executive, because the head of the executive, who is the president, does play some kind of role. All right, so that's codified and uncodified, right? So well, that's codified. In the UK, it's uncodified. So the rules are more flexible because much of it is regulated by convention. So there's more of a flexible system. So that's why we call there's more of a balance of powers, where one steps in to balance the other, a checks and balance mechanism in that sense. Okay. Number 4, however, in the UK, there are overlaps. So in the other question, I divided it into 3 overlaps between the L and the E and the J and the E, like that, right? But for this one, I'm not really going to divide it in that way. I'm going to do it a bit differently and discuss the overlaps generally, all right? Pick some that I want to talk about. Okay, so it's not absolutely necessary that you divide it into 3 bits, the L and the E and the J and so forth, right? You can actually give different examples, and talk about it generally, which is what I'm going to do now. So when I think of the overlaps, the one that it's perturbing to me particularly is the overlap between the L and the E, and particularly in terms of membership. And I said in the earlier question, the 2019 question in part 1, the part 1 SOP video, that this overlap is of membership is supposed to be checked and is supposed to be regulated by a scrutiny mechanism through ministerial responsibility, through answering in Parliament. But that doesn't always work well. So I mentioned that the balance here, there's not really a balance to, if we look at the words of the question, a balance of powers. Sometimes there's no balance of powers and Parliament becomes dominated by the executive. The executive manipulates, it dominates Parliament to be able to bulldoze whatever legislation they want to get through. All right? So that's sometimes not a balance in that sense. Overlap in terms of delegated legislation. After the European Union Withdrawal Act of 2020 has been passed, we now know that ministers are given more delegated legislation powers in order to make the preserved EU legislation to be transferred, to be made into domestic British law. Now, in order to be a lot of cut and paste going on of legislation, and ministers are going to be given that. They already have these delegated legislation powers. Now, what are the checks and balance here? Is there a balance of powers? We don't know. It's yet to be seen. All right. So that's overlaps between the L and the E. If you look at number 2, other significant overlaps. So, for example, you might want to talk about the overlap between Parliament and the judiciary in the sense of the problem of parliamentary privilege and how Parliament regulates this issue, and whether anybody has acted in contempt of Parliament. Parliament decides who will be punished, which is a judicial function. And there's no real balance here. There's no real checks and balance here, because it's a non-justiciable issue. The case of Al-Fayed, Alfayed, tells us that parliamentary privilege is a non-justiciable issue. Okay, so that's an example where sometimes the balance may not, the balance of powers may not actually be there. And we can also see that between all three of these institutions, the one really that cannot be balanced out is really the might of Parliament, and how Parliament at the end of the day can really get away with doing whatever it wants. So if Parliament wanted to enact the War Damages Act, which had retrospective effect, it could do that even after the Burma oil case was decided. So that is an example. There are other examples here of overlaps, significant overlaps. So for example, the third circle bullet point there, under other significant overlaps in the 3 branches, government officers who are part of the executive, like the Attorney General, may also be exercising a quasi-judicial function. When you start and stop criminal prosecutions, that's a judicial function. All right. And in addition to exercising a judicial function, the courts sometimes, may decide to make law when they develop principles of common law and equity. That's what they're doing. Government ministers may be exercising a judicial function if they, determine appeals, relating to town and country planning legislation, asylum, immigration. So here we see overlaps as well. Okay. And then if you look at the next overlap that I've mentioned, number 3, reforms to the office of the Lord Chancellor. So you might have also mentioned the office of the Lord Chancellor in the past, how in the past it was controversial, but that has been remedied to a large extent through the Constitutional Reform Act of 2005. And the main changes of the Constitutional Reform Act of 2005 on the role of the Lord Chancellor are stated on your page 15. Okay, I beg your pardon, on your page, at the top of your page 16, and they are as follows. Let me just repeat them so that you're absolutely clear. The first is that the Lord Chancellor is no longer the head of the judiciary. Okay, so that role is now performed by the Lord Chief Justice. Okay, and that's section 7 of the CRA of 2005. The second is that the automatic link between the Lord Chancellor and being Speaker of the House of Lords, that's also been cut off. The Lord Chancellor does not sit as a judge in the Supreme Court, and the Lord Chancellor role today is mainly as the senior minister in the cabinet. Okay, now, and then other things that you can talk about also are, for example, on that page 16, when we're looking at separation of powers and the balance of powers, whether there's a balance of powers, there can only be a balance of powers if there is judicial independence. Without judicial independence, there cannot be a balance of powers. So you need to question the role of the judiciary in relation to lawmaking and judicial review. So I've asked that question, is the judicial power, is it the weakest of those 3 government departments, the L, the E and the J? And when we look at that whole interaction between Burma Oil and the War Damages Act, we do see that the judiciary is, somewhat vulnerable, isn't it, in the face of an almighty parliament. So in that sense, what balance of powers are we talking about? Now, how can we rebut that? How can the judiciary rise above that and say that, look, there is a balance and we do play our part? Well, the judiciary can point to the Act of Settlement of 1700, of their security of tenure. They can point to the vast development of administrative law cases that they have helped to expound, cases like Padfield, Annis Minnick, Wensbury, GCHQ, the principles of judicial review, the grounds of review. These have all been things that the judiciary has done to show that they also have power. So that balance of power, so to speak, is not has not been completely taken away by them. So they do have the tools to develop principles of common law and equity. They do have the tools, as it were, to, for example, that next case that put SOP and the important case of A against SOS, the Belmarsh prison case. They do have the important tools of sections 3 and 4 of the HRA, which they used, in a clever way, in a sense, in the Belmarsh prison case, to come out with a declaration of incompatibility, to say that, section 3, which is their duty to interpret the law compatibly with convention rights. That means to interpret section 23 of the Anti-Terrorism, Crime and Security Act of 2011, which allows for indefinite detention without trial. You have to interpret that compatibly with Article 5 on liberty, Article 14 on non-discrimination. They couldn't do it. So they came out with a declaration of incompatibility. So when a DOI is made, the interaction between section 3 and 4, that preserves the balance of powers. That preserves what we call the institutional balance. Now, that's a nice phrase for you to remember, the institutional balance. Now, when we talk about the institutional balance, we mean the balance between the L, the E and the J, and in particular, the L and the J, Parliament and the judiciary. So section 3 and section 4 maintains that balance of powers between the L and the J, the institutional balance. And cases that you can talk about to substantiate that argument would be, for example, the Ballinger case, the Belmarsh prison case, the Anderson case. To discuss those cases, discuss the interaction between section 3 and section 4 of the HRA, your conclusion should be that SOP is preserved. The balance of powers between the L and the J is preserved. Okay? At the excuse me. These are the perils of talking too much like a zombie non-stop. Okay. Now, at the bottom of page 16, other examples of checks and balances by the judiciary, the case of Public Law Project against Lord Chancellor. Now, what is this about? Now, this is about when, let's say you have got subordinate legislation, that means delegated legislation, which is questionable. Can the judiciary question it, whether it is ultra vires, outside the powers? The answer is yes. And that's what they did in this case. They said that, look, the subordinate legislation, the SI, the statutory instrument made under the Legal Aid Sentencing and Punishment of Offenders Act of 2012 is ultra vires. It's invalid, it's void. Because why? Because it went beyond the powers given by Parliament. Another very good case that illustrates this is the Supreme Court decision of Unison. You remember Unison? UNISON, where the fees that imposed to bring a case to the tribunal, the fees were imposed to make it what? Something that affected accessibility. And the Supreme Court said that it impedes accessibility. It's a violation of the rule of law principle. It's invalid. So these are decisions that tell us that what? The courts do rise up to that occasion to maintain this balance of powers, for them to be able to use judicial review in a manner to question the legality of the decision-making process. So that balance of powers is still something to believe in. The judiciary is still not too badly off. Bottom of page 16, the recent cases of Miller, both number 1 and number 2, and I explored this in the earlier video, which was part 1, the meaning of justiciability. So I emphasized that Miller number 2 tells us that the concept of justiciability in itself is a malleable concept, and it depends on which judge you are actually asking. All right? So in just 1 second, there's someone talking outside. I'll just go and tell them to shut up. Okay, somebody was talking outside. Sorry about that noise disruption. Right, so bottom of page 16, you've spoken about the Public Law Project against Lord Chancellor case, the Unison case. These are examples of showing how the courts can declare delegated legislation to be unlawful. Of course, bear in mind that they can do this because it's delegated legislation. If it was not delegated legislation, if it was an act of parliament, they can't do that. So both the Public Law Project against Lord Chancellor decision and the Unison decision would have had different results if it was not delegated legislation. They would not have been able to say it is unlawful. So in that sense, the balance of powers is there if they can question delegated legislation. But if it's a primary act, they can't do that. The only thing that they can do is to come out with a DOI, but that also is only if there is an ECHR issue involved. If there's no ECHR issue involved in the matter, they can't come up with a DOI as well. So again, we may say that the balance of power there may not be really a balance, that Parliament at the end of the day is the boss, so to speak. Right? Now, if you turn to page 17, so that actually covers the checks and balances that we were talking about just now. So when I spoke about the balancing process, the reason why I keep going back to the word balance of powers is because the question talks about balance of powers. So point number 5, discussion number 5 under checks and balances on page 17, in a sense we've already done all that. I've spoken about the importance of the HRA, about how using sections 3 and 4 and the DOI acts as a checks and balance, but I also told you that this can only happen if there's an issue concerning the ECHR. Otherwise the HRA doesn't kick in. You can't make a DOI. You can only make a DOI if it is an ECHR issue and there's been a lack of compatibility. All right, otherwise you can't. Yeah. Okay. Now, so at the end of the day, what further reforms have happened? So you know what the Constitutional Reform Act did. It modified the role of the Lord Chancellor. It also created a new Supreme Court. These are all good things. The law lords were removed. The JAC was formed. But point number 7, are there future reforms that we could suggest to create a better sense of separation of powers? And the answer is yes. One of the suggestions to take forward, which I've put at the bottom of page 17 on appointment of judges, you might want to talk about section 61 of the CRA, which established the Independent Judicial Appointments Commission, which is responsible for selecting candidates to recommend to the Lord Chancellor for judicial appointments. Okay, so this is a good thing because it significantly reduces ministerial discretion in the appointment process, but it's not a perfect system, yeah, because the JAC is a recommending rather than appointing body per se. So in that sense, there is a need for further reforms in this area. Number 8, different schools of thought on SOP. You might want to contrast some judicial and academic opinion on this. So judges like Sir John Donaldson in Ex parte Smedley say that it's a constitutional convention of the highest importance. The L and the J are separate and independent. So if you look at both Smedley and Dupont Steele's, the judges are talking about a separation. They are admitting there is definitely SOP between the L and the J. So judges will always say that there is a separation between the L and the J, all right? But if you ask judges on what is the meaning of the concept of justiciability under number 9, you will see that sometimes it's very clear. So at the bottom of your page 18, judicial review and the concept of justiciability, I've added the recent decision of Wilson there. And Wilson is about a claimant who is saying that, oh, the EU referendum, he said, you know, there are irregularities in the referendum. And the court said, look, we're going to say the same thing we said in Wheeler so many years ago. You come and ask us things about the referendum, technicalities, blah, blah, promises made by the government. These are all political issues concerning the referendum. We don't want to get involved. So there you see a clear demarcation. What's a political issue? What's a legal issue? Of course, sometimes that demarcation is not absolutely clear, as the Miller decision tells us, if you turn to page 19. So in your conclusion, yes, you can actually bring the Miller decisions, and Miller number 1, of course, tells us that the Sewell Convention is a political convention. The courts don't want to enforce it. But Miller number 2 tells us that what? It says, Lady Hales said that the politics and law sometimes, you know, they mix, and the court is not going to shy away, isn't it? If you remember the quotation that I read out just now on your page 23, remember what Lady Hales said in Miller number 2? Although the courts cannot decide political questions, the fact that a legal dispute arises from a political controversy has never been sufficient reason for the courts to refuse to consider it. Many, if not most, of the constitutional cases in our legal history have been concerned with politics in that sense. So that brings us nicely to the end, to our conclusion. So conclude by saying, at the end of the day, does the UK Constitution resemble more of a balance of powers than a formal separation of the 3 branches? You know, yes, there's certainly no formal separation. Is it more of a balance of powers? Yes, in theory, but as this answer is established, sometimes there's no, you know, complete equilibrium. One branch might dominate another, particularly Parliament in some instances. But at the end of the day, it is a concept, separation of powers is a concept that is there. It works in a flexible way. The last quotation there, Munro says that it should not be lightly dismissed. All right, and Lady Hale herself in Miller number 2 says that what? The concept of justiciability is what? Is malleable, isn't it? So to her, prorogation of Parliament was a justiciable matter. To the High Court, it wasn't. Yeah. So that tells us that there is a fluidity, there is a flexibility with the way in which this doctrine operates in the British Constitution. Right? So that brings us to the end of this question. Very nice. I've managed to finish that in 30 minutes. So thank you for your attention, and I will see you in the next video, which will be session number 6. All right, so that will be on ministerial responsibility. I'll see you then. Thank you. Bye bye.